Hello everyone, my name is Giovanni Nogales and I'm a paralegal here at Laos Parker. Welcome to today's webinar hosted by the Texas Associations for Home Care and Hospice. Today's webinar is entitled Hospice, TPE, SERT, SMRC, SFP, PPEO, and UPIC audits, top denial reasons and the possible impact of these audits on other enforcement activities. Today's presenters are Robert Saltaformaggio and Matthew Catoe. Robert Saltaformaggio is a senior counsel at Laos Parker. He focuses on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Robert represents clients nationwide. He has experience in assessing clients' records for documentation compliance in private payers and CMS audits preparations, as well as identifying and improving documentation deficiencies. As for Matthew Catoe, is a new associate with the firm. Prior to his time with us, he had worked with HHS and OIG, both their investigations team and with their office counsel. He's since come back from the dark side and brought experience in audit kickback, Stark Law, and False Claim Act compliance matters. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we'll address as many as possible at the end of the presentation. And I will also be sending a copy of the PowerPoint slides via email tomorrow. So without further ado, I present your speakers, Robert Saltaformaggio and Matthew Catoe.
Thanks, Gio. This is Robert Saltaformaggio, and along with my colleague, Matt, we appreciate everyone's time today. As Gio stated, we're going to talk about some of the Hospice, TPE, CERT, SMRC, SFP, PPEO, and UPIC audits, as well as some of the laws surrounding these issues and other enforcement activities on behalf of the government. Next slide. Before we begin, I really like this quote from Justice Neil Gorsuch in his new book, which he says, "Criminal laws have grown so exuberantly and come to cover so much previously innocent conduct that almost anyone can be arrested for something." And I know, especially in the healthcare space these days, it just seems like everywhere you go, you're walking on eggshells with regard to all the new rules, guidelines, regulations, and laws that are affecting you as a hospice or home health provider. And that's where folks like Matt and myself come in to kind of help you navigate so that you can get around that minefield and be successful in your line of work. Next slide. Briefly, I just kind of want to give an enforcement overview from the government. Now, this slide is slightly outdated now that we have the new Trump administration in place, but I think it's still going to be helpful for you. So back during the Biden administration, what they did was they really focused their enforcement efforts on holding all individuals accountable who commit or profit from any corporate crime. Now, this was a slight transition from the Trump administration in which they focused a lot on those who might be, quote, substantially involved in criminal matters. So, that might be the CEO, CFO, COO, a lot of the big fish for folks, in the entities, especially in some of the larger organizations. And so, if you were a normal administrator or worker within the line of business, you might not be targeted in anything involving criminal matters. Well, the Biden administration kind of transitioned in that, and again, they started focusing on all individuals who might be involved. And so, really, towards the end of the Biden administration, you really couldn't avoid any personal liability by trying to hide behind, the corporate shield or any of the officers at the organization. I think one thing we've yet to see is whether or not the new Attorney General, Pam Bondi, will kind of transition back to the guidance in place in the first Trump administration, or whether they'll kind of continue this individual accountability that was put in place by the Biden administration. Next slide. So this slide kind of shows that we continue to see increased settlements and judgments from civil cases involving fraud and false claims against the government. For FY 2024, so that begins in October 2023 through September of 2024, those claims against the government exceeded 2.9 billion. And of that amount, more than 1.67 billion was attributed to healthcare related cases and matters. And so, you know, outside of 2021, in which there was an extreme spike in these matters, which, you know, I think at that point the government was really targeting a lot of COVID-related fraud. You've just kind of seen a steady increase year over year. And notably, that 2.9 billion did not even include two significant settlements that were each nearly $500 million each that occurred in just the week and about 10 days after the close of the fiscal year. So they were at the beginning of October 2024, which could have put that number well over 3 billion. So, you know, we might see a spike in the FY 2025 numbers when they come out next year. Notably, during fiscal year 2024, almost 1,000 whistleblower cases were filed, which was the highest number in a single year. So as you either might know or might not know, the False Claims Act has a key tam or whistleblower provision that allows whistleblowers to you know, help the government identify any alleged fraud or false claims within a respective entity. And then finally, during FY 2024, the DOJ and whistleblowers were party to more than 550 settlements and judgments, which was the second highest number in a single year. So, you know, in sum, really 2024 was a big year for the government in going after, you know, healthcare fraud and fraud in general. Next slide. So, you know, as the previous slide noted, that a significant number of the settlements and cases from a monetary perspective involves healthcare related fraud, but even from a typical numerical sense on those charged and convicted with fraud also come from the healthcare space. So, you know, the DOJ's fraud section really has three primary sub-entities. Some of the prosecutors focus on areas related to the Foreign Corrupt Practices Act, and that's really on global corruption. Others focus on the cases related to the market integrity and major fraud, which this is related to bank fraud, mortgage fraud, securities, commodities fraud, etc. But again, as you can see that, you know, more than about 60% of those individuals charged with fraud come from the healthcare space, and about 65% of those convicted come from the healthcare space. Next slide. So kind of doing a 30-year look back at, you know, who is involved in these criminal prosecutions. Well, most of the organizational offenders are domestic, private, and small businesses. So these really are your mom and pop healthcare providers and not some of the big corporate entities that, although they might have significant fraud from a monetary perspective, the number of cases and those involved really come from your mom and pop shops. Unfortunately, an overwhelming majority of the offenders did not have any compliance or ethics program in place. And then only 11 of almost 5,000 organizations who were criminally prosecuted received a sentencing reduction for that effective compliance and ethics program. Again, and only 1.5 received a sentencing reduction for disclosing an offense prior to a government investigation. You know, as part of, you know, the 7 elements of an effective compliance program, one of those is, you know, performing your self-audits, and in doing so, that might be one way for you to identify any errors that you might be making, and that could report any alleged overpayments to the government in a timely manner before it kind of spirals out of control and you start to see the hand of DOJ come after you. So, you know, while, you know, as I noted in kind of one of the earlier slides, while criminal prosecutions of companies have declined, the DOJ is again focusing on all those individuals who are involved in criminal activity, and those prosecutions have increased. Next slide. So first we'll kind of just talk about our folks in the home health space. So there's a number of administrative audits that are occurring in the home health against home health providers, and those include your ADRs, your TPE, and UPIC audits. And some of the top denial reasons we're seeing, which, you know, of course, there's allegations that to an extent skilled nursing, and maybe to a lesser extent some of the therapy, whether it's physical, occupational, speech therapy, were not medically reasonable or necessary. So it's important for you here to be routinely performing chart reviews to ensure that your documentation supports that either skilled nursing or the therapy services performed at each visit were medically reasonable and necessary, and you're documenting any response from the patient to that treatment. You're documenting progress towards the patient's goals and any plans for the next visit. You're also wanting to make sure that, you know, the patient remains homebound, and that status is also supported throughout the episodes of care. Second, we're seeing issues with the initial certifications either being missing, incomplete, or invalid. So, you know, not only will that affect the initial episode of home health services, but then all the subsequent recertification episodes are going to be tainted. So you really need to have a process in place to ensure that all the required elements of the initial certification as well as any subsequent certifications are met before you submit the claim, the bills to be paid. Next, you know, providers are encountering issues where the medical documentation submitted doesn't show that the therapy services were reasonable and necessary, kind of like I mentioned with the first bullet point, or that they're at a level of complexity that requires the skills of a therapist. I've seen that issue a lot, where, you know, the government auditor is alleging that the services the therapist provides is something that the beneficiary and or his caregiver can perform, and that, you know, you really don't need the government paying for a therapist to come in and perform. Next, we see a number of denials because the providers are not responding to the ADR request or the UPIC records request within a timely manner. You know, sometimes, especially with the post-payment reviews, these contractors can be amenable to, you know, extend the deadline, but it really takes you or your legal representative to engage the contractor and get that, you know, in writing, so that if you do get that extension, that when you do submit the medical records, you have documented proof that you've been granted that extension. Otherwise, they're going to point to those regulations and say, hey, you didn't submit the records within, you know, either the 30 or 45-day period. And then finally, we're seeing deficiencies with the face-to-face encounter. You know, agencies must verify that the face-to-face encounter for that initial certification is included in the patient record, especially when you submit those records in response to the records request. You want to make sure those face-to-face encounters are timely, that they're performed by an allowable practitioner, and that they support the primary reason for the home health services. I can't emphasize enough that I've seen that error a number of times, where, you know, the patient will see the allowable provider for one issue, and then the patient is certified for home health services on a completely separate issue. So the contractor will go in and say, well, hey, that doesn't make sense. He was referred for X reason, but certified for B reason. And, you know, and then finally, you want to make sure that the signature and dates are within the allowable period, and that there's a valid signature by the allowed practitioner. Next slide. So we oftentimes like to show just some examples of your peers in the home health industry who have not really aligned themselves to an effective compliance program and then have gotten in trouble. So this first case comes out of the Eastern District of Texas. For those not knowledgeable, Texas has 4 federal districts: the Northern District, Eastern, Southern, and Western. So here we have an owner and operator out of 5 Houston area home health agencies that was sentenced to 480 months in prison for defrauding Medicare and the Texas Medicaid agency. And according to the plea agreement that the defendant and his co-conspirators entered into, they obtained patients for the home health agencies by paying illegal kickback payments to patient recruiters, and his office employees for hundreds of patient referrals. It is also, they agreed that they paid Medicare and Medicaid patients by various means for receiving services from his family's home health agencies in exchange for their ability to use the patient's Medicare and Medicaid numbers to bill for programs for the home health care as well as provider attendance services. They also directly paid patients for recruiting and referring other Medicare and Medicaid patients to his agencies. And additionally, they paid physicians illegal kickbacks in which the defendant and his co-conspirators called co-payments for referring and certified Medicare and Medicaid patients for the home health and provider attendance services. Another case out of the Eastern District where we had a defendant who was charged with conspiracy to commit healthcare fraud in connection with a scheme where he fraudulently obtained over $1.5 million in Medicare and Medicaid funds. According to the indictment, the defendant owner billed Medicare and Medicaid for home health services that were not provided or medically unnecessary and were based on an illegal kickback payments to marketers and patients. Next slide. Again, in the Eastern District, owner and operator of a Houston-based home health company allegedly paid recruiters and doctors to bill for Medicare for home health services using the beneficiary Medicare information, regardless of whether they needed the home health care services or not. So again, wasn't medically reasonable or necessary. Out of the Northern District, we have a physician and 2 nurses who were found guilty of healthcare fraud. And according to the evidence, the defendants engaged in a scheme to defraud Medicare by submitting and causing the submission of false and fraudulent claims to Medicare through their home health agency and physician house call company. The evidence showed that one of the defendants, who was a doctor of osteopathic medicine, certified Medicare beneficiaries, many of whom he had not even seen or did not care to see, for medically unnecessary home health services that were also not even provided. The evidence also showed that one of the registered nurses failed falsified nursing assessments, while another, who was a licensed vocational nurse, falsified nursing notes to make it appear as if the Medicare beneficiaries were qualified and were provided skilled nursing services. And then finally, down in South Texas, we have the owner of a home health agency who allegedly paid marketers and group homeowners for Medicare beneficiary information, in which he used to bill Medicare and Medicaid for services that were not provided or didn't qualify for coverage and payment. The owner also allegedly personally falsified home health patient assessment forms to make the beneficiaries appear sicker in order to receive higher reimbursement rates. And he instructed his employees to falsify home health certification and forge physician signatures. So, overall, what are kind of the similar facts we're seeing here? Providers are certifying patients who, where the home health services are not medically reasonable or necessary. They're forging documents, forging orders, and there's also illegal kickback schemes, whether that's to marketers or other patients in order to refer patients to their services. And Matt will talk later about the anti-kickback statute and how that's legal. Next slide. So now we can kind of just turn to hospice and some of the administrative audits that are going on in the hospice field. First, we have this hospice special focus program audits. These audits have been designed to monitor hospices identified as poor performers based on certain quality indicators. Hospices selected for review under this program are given additional oversight that's intended to help them improve their performance and then make sure that they're remaining in compliance with not only the services they provide, but then with all the claims that they're submitting for reimbursement. Hospice agencies that are unable to resolve any identified deficiencies that led them to this review may be terminated from the Medicare program. Not only just termination, but then Medicare also has the option of imposing other enforcement remedies. So you want to stay clear of that. We have the PPEO, or the Hospice Provisional Period of Enhanced Oversight. So back in July of 2023, CMS announced that it had received numerous reports of hospice fraud, waste, and abuse over the prior year. So that during this time, CMS noted that a number of enrolled hospices had greatly increased in several states, one of which was Texas. And so they placed several, many of these hospices under the PPEO audits, and poor showings under these reviews have resulted in revocation of hospice enrollment programs. Some of the primary denial reasons that we've seen with these are, the eligibility for hospice services is not properly documented. So you want to make sure, I'm sorry, let's skip ahead. The documentation submitted does not support the prognosis of 6 months or less. This is by far the #1 reason we see with hospice denials, regardless of, where the hospice is located in the U.S. And, I know there in Texas, the Medicare administrative contractor is Novitas. So, you got to make sure that your eligibility requirements are met upon admission. And, the guidelines are outlined in Novitas's LCDs for hospice. And, you not only upon admission, but then throughout the care, you really need to make sure that the beneficiary, that there's continued documentation to support the beneficiary's terminal prognosis. Next, we see a lot of denials related to the physician narrative statement, either being not present or not valid. So some hospices are still unclear that the certifying physician is required to be the author of the narrative statement that's included on that CTI, the Certificate of Terminal Illness. If you have an EMR system that just prints out generic certification statements and then sign it with no clinical content specific to the patient, that's just a denial waiting to happen. And one thing I really like to emphasize here is that it is a physician narrative. So I've seen many denials where in this section the physician will just list the beneficiary's comorbidities and chronic conditions and not really elaborate in a narrative that how those conditions relate and kind of are causing the terminal illness. You don't need a book. CMS doesn't need you to write a book, but it really needs to be a narrative and not just a list of diagnoses. Next, the hospice selection statements doesn't meet the statutory or regulatory requirements. We're also seeing issues with no certification for the dates billed. So if you do get those records requests, you want to make sure that you're submitting all the documentation for that certification period. And then finally, we're seeing issues with the hospice continue care hours being reduced. Next slide. So if you're in the hospice state, it's fair. I'm sure many of you are aware of TPE audits, the targeted probe and educate audits. And, we really like to emphasize that these are serious business. If you're subject to a TPE audit and fail to, achieve an acceptable level of performance, the MAC will refer you to CMS for additional possible action. And as you know, there are 3, levels of TPE. So kind of CMS is giving you multiple opportunities to identify the deficiencies either on your own or through their review process, and then correct those deficiencies so that, if you don't get an acceptable error rate and have to move to, TPE round 2 or hopefully not move to TPE round 3, you're demonstrating that through each subsequent round that you are showing improvement and really listening to the feedback that you get. Because at the end of each TPE round, you're going to have education by the provider specialist who can come in and help you, and not only them, but engaging counsel to help you identify. So it's really important that you take these TPEs seriously, so that if you're not fortunate to have a successful round 1 score, at most you're just going to be subject to a round 2. Again, the TPE primary denial reasons are going to be consistent to what we see in the previous audits for the PPEOE. Eligibility for hospice services is not properly documented, or issues with the meeting the qualifications for terminal diagnosis under the LCDs, either a missing face-to-face documentation. As you know, in the hospice, it's required for the 3rd benefit period and every subsequent benefit period. And for the 3rd one, missing or incomplete certifications and recertifications. For those last 2 bullet points, another issue I've seen kind of that go together is, the physician will certify that he used, the face-to-face, the clinical information outlined in the face-to-face encounter to draft his physician narrative and certify the patient for subsequent care, where come to find out the face-to-face document is signed and dated subsequent to the CTI. So, we've seen the Medicare contractors ask, how can the physician use the information that's obtained at a later date to certify the patient? So, as with all of these certification requirements, you want to make sure that they're timely and they go in the appropriate order. Next slide. So these CERT audits, I would say out of all the audits we kind of talked about, CERTs are probably the least worrisome. So the most recent CERT audit report came back in 2023, and that they were kind of looking at the improper payment space for all hospice services, and identified that during that reporting period, there was 1.3 billion in improper payments, and that resulted in an improper payment rate of 5.4%. Really, Medicare uses these CERT audits to kind of audit their contractors. So while, again, they're requesting your records and you're going through the process, CMS is also making sure that its contractors are performing their duties correctly. And, with these CERT audits, the primary denial reasons, again, are really consistent across the board. You're having inadequate or deficient physician certification or recertification forms, issues with the criteria for the beneficiary's election forms, the physician certification documents were signed and dated after the claims were submitted, or as I mentioned earlier, the certification is performed before the face-to-face encounter, or you're having inadequate face-to-face documentation, or again, missing face-to-face documentation. Next slide. And then finally, we have these, or I guess I shouldn't say finally, but in addition to kind of these CERT audits, we also have SMRC audits, the Supplemental Medical Review Contractor, and these are performed by another MAC, Noridian. And again, they've kind of just been conducting these audit hospice services to determine whether the proper level of care was being billed. For these SMRC audits, contractor found that in several cases, the beneficiaries were not suffering from uncontrolled pain or did not have unmanaged symptoms. In many cases, the patients didn't qualify for hospice with a terminal diagnosis. So while SMRC audits were kind of infrequent in 2024, we likely might see an increase in those audits for 2025. And again, the primary denial reasons are really consistent across the board. And we just want to emphasize that if you do poorly in a SMRC audit, the negative results can be used as part of a justification cited by CMS in either suspending a provider's billing privileges, or in a worst case scenario, revoking. Because one of the bases for CMS to suspend or revoke a provider's billing privileges is a consistently high error rate from these audits, and that kind of demonstrates to CMS that you have a pattern of practice of improper billing. Next slide. And finally, we have these UPIC audits. These are pretty standard and consistent, not only for hospice providers, but home health and just providers in general. So these guys, the Unified Program Integrity Contractors, have been contracted to detect, deter, prevent waste, fraud, and abuse in both the Medicare and Medicaid programs. So, these guys, they're really program integrity auditors, and they each have their kind of designated geographic region similar to the MACs. The primary denial reasons, again, are consistent across the board, where there's issues with the beneficiary's eligibility for hospice. There are issues with the beneficiary election documents or consent forms. We've seen issues where their providers were billing for a higher level of care than was necessary. And then one other problematic is that the hospice care was rendered by unqualified or unlicensed clinical personnel. Next slide. So, moving away from the Medicare contractors, OIG has also ramped up its auditing of hospice claims around the country. Some of the consistent denial reasons we're seeing, again, hospice eligibility requirements are not met, where the clinical records do not show that the beneficiary is meeting the guidelines for hospice outlined in the LCDs. The physician certification or recertification doesn't meet the requirements required by Medicare, and issues with the face-to-face encounter, whether it's missing or the documentation is inadequate. Also seeing issues with hospice services not being properly documented, so you want to make sure that the nurses or other the hospice aides or whomever, that you have appropriate documentation for any claims that you're submitted. And then, like I kind of mentioned in the previous slide, the level of care was not being supported, whether that's the just inpatient care or the continuous home care. Next slide. So earlier I kind of flagged some criminal cases involving home health. I'll kind of just end this section with discussion of some criminal hospice cases. So out of South Texas, we have a medical director of a large health care company that operated dozens of locations throughout Texas. And he was recently sentenced for his role in submitting over 150 million in false and fraudulent claims. He was also ordered to serve 50 months in federal prison and ordered to pay $9 million in restitution and forfeit another $9 million. So this defendant and multiple co-conspirators marketed their hospice programs for various, through various companies. And so in some instances, the company marketers falsely told patients that they had less than 6 months to live. And it was also noted that they sent chaplains to these patients, telling them that they only had 6 months to live. The company hired the defendant and other medical directors, but made the payments of medical director fees contingent upon agreeing to certified unqualified patients for hospice. In addition to these medical director payments, the defendant was receiving luxury trips, auto service, and other perks in exchange for certification of these hospice patients. So just a number of no-nos that Matt will discuss later about how this is just wrong. And then in the North District of Texas, we had an owner of a hospice in Texarkana who agreed to pay $4.2 million to resolve FCA violations, in which it was alleged that he knowingly submitted false claims and knowingly retained overpayments for the care of his hospice patients who were otherwise ineligible for the hospice for the Medicare hospice benefit because they were not terminally ill. Next slide. Okay, now I'm going to turn it over to my colleague Matt, who's going to discuss the anti-kickback statute. Matt.
Thanks, Robert. So as we mentioned in several of the previous cases that Robert's been walking through, one of the big enforcement mechanisms for these types of cases is the anti-kickback statute. It was published in the Social Security Act of 1972, and we have on screen an evolution of the scienter and intent requirements. Scienter is a legal term of art that means essentially knowledge, but it's more convoluted than that because, of course it is, lawyers are involved. But also the intent requirements under the anti-kickback statute. Eventually, this was reconciled under the Omnibus Reconciliation Act of 1980, where legislators amended the Social Security Act to require proof of both knowing and willful conduct that as a prerequisite element to any case brought under the anti-kickback statute. Next slide, please. The modern version is codified at 42 USC section 1320A through 7BB. If you would like to read them at your own discretion, that is the citation that you may plug into Google and it will pull up. Under the anti-kickback statute, it is a crime to, once again, knowingly and willfully solicit, receive, offer, or pay any remuneration in return for 1, referring or arranging for services payable by any federal or state healthcare program, or 2, purchasing, leasing, ordering, or arranging for any goods, facilities, or services that may be paid for in whole or in part by any federal or state healthcare program. Translated from legalese, this is a crime to knowingly and willfully refer or arrange services for any services payable by any federal or state healthcare program, meaning if it touches a federal or state piggy bank in any way, and they can prove you knowingly and willfully offered a referral or a kickback, hence the anti-kickback statute, it is a felony under this statute. Additionally, purchasing, leasing, or ordering for any arrangement of goods, services, facilities, or otherwise, usually durable medical equipment, but also other medical devices used in medical care that, once again, paid for in whole or in part by any federal or state healthcare program, can be charged as a criminal matter under the anti-kickback statute, as well as proceeded under civil grounds simultaneously. Under Section 6402F2 of the Affordable Care Act, a person need not have actual knowledge of this section, nor specific intent to commit a violation of this section. This means that not only is ignorance of the anti-kickback statute not a defense, meaning you didn't know the conduct was illegal, but also, two, they don't require a specific intent, meaning they don't need to find a smoking gun, email, text chain, whatever it may be that says we know what we're doing is illegal. It can be surmised based on the amount of evidence that investigative authorities choose to put forth when they're proceeding under the anti-kickback statute. This change is very noteworthy because it lessens the requirements for the government to bring a criminal case under the anti-kickback statute. They can and will bring a host of circumstantial evidence as opposed to a single smoking gun email that says we know what we're doing is illegal, and that can and has stood under the anti-kickback statute. Next slide, please. So the penalties can include the items listed on your screen. First and foremost, penalties do include a possibility of prison time, up to 10 years prison per charge, as well as a fine of up to $100,000 per charge. It can also include exclusion from participation in federal and state healthcare benefit programs. Additionally, there are civil monetary penalties, or CMPs, of up to $50,000 per violation, and assessments equal to not more than 3 times the amount of remuneration paid under the arrangement. That last sentence is what is referred to as the treble damages provision, which means that at the end of the charging documents, once the government has proven their case and we are going to sentencing or otherwise the last stages of a procedure under the anti-kickback statute, the equal to not more than the amount 3 times language is treble damages, which means they can take the $100,000, the $50,000 per violation, and put a 3 times multiplier on it, up to 3 times, just because that is written in the statute. And the government has and will continue to use treble damages as an example to dissuade people from engaging in otherwise illegal conduct. Most courts have adopted a very expansive reading of these statutes, including the Greber case from 1985, shown on your screen. The Third Circuit adopted a, quote, one-purpose test. The Greber court held specifically, if the payments were intended to induce the physician to use the alleged offender's services, the statute was violated, even if the payments were also intended to compensate for otherwise professional services. This, boiled down to its roughest core, means one purpose, one falsity, one charge under the anti-kickback statute can taint the whole batch. The one bad apple can spoil the bunch, as it were. So we encourage providers to be very aware in the event anti-kickback statute allegations are leveled against them or their practice, that it can get very serious very quickly, and we encourage you to reach out to legal professionals for help, whether that's SALT and whether that's Robert and myself here at Lyles Parker or another attorney's firm. We do want you to take these very seriously because, as you can see on your screen, the penalties can get very steep very quickly. Next slide, please. There are some safe harbors. As the anti-kickback statute reflects, the scope of potential coverage under the law is extraordinarily broad. In recognition of this fact, the 1987 Congress authorized DHHS and the OIG to issue safe harbors for certain specified business arrangements and practices that ordinarily could be considered a violation of the AKS, but for the carving out of the statute. And they would be permitted so long as certain safeguards are put in place to prevent fraud and abuse. all safe harbors are voluntary. They are not mandatory, and they are very specific. While a given arrangement is not necessarily a violation of the anti-kickback statute if one or more of the elements in a safe harbor have not been met, a provider is effectively precluded from relying on a safe harbor as an absolute defense. Once again, translated from legalese, this means that each individual safe harbor under the anti-kickback statute has a very specific checklist of the safeguards that HHS and the OIG have demanded be in place in some form or format in order for the safe harbor to apply. If you miss one of these checkboxes, it can compromise the entirety of the defense of the safe harbor. The number of safe harbors to the federal anti-kickback statute is subject to change per legislative appeal, and there are currently 11 statutory and 36 regulatory safe harbors. Next slide, please. The most likely safe harbors we've seen in the home health and hospice agencies are on your screen. The first is the personal services and management contract safe harbor, and the second is the employment safe harbor. As I mentioned previously, each of these safe harbors are very complex and typically require a legal assessment to determine whether a proposed business arrangement qualifies and meets the specific checklist of the safe harbor the business is attempting to slot itself into. Physician ownership of home health or hospice agencies may, for example, be protected under the small entity investment safe harbor, but compliance is incredibly complex, and meeting every element of that safe harbor is generally impossible in practice. Once again, you are strongly urged to consult healthcare counsel if you believe that your business arrangement may run afoul of the AKS and you want to take advantage of one or more safe harbors. We strongly encourage you to retain counsel to review the arrangement if you are even suspicious. Next slide, please. A walkthrough for brief edification. This is the citation for the personal services safe harbor. Under the final rule in December of 2021, several changes were made to the personal services. Prior to the issuance of the December 2021 final rule, in order for personal services and management contracts to qualify for coverage under the safe harbor, aggregate compensation had to be set in advance. This made it incredibly difficult for indeterminate hourly compensation, per diem business arrangements, and per claim compensation arrangements. Under the modified rule, however, only the methodology has to be set in advance. A number of other restrictions are in place with this safe harbor, but this 2021 final rule, the correct word is broadens, but not so much as a normal action would broaden a safe harbor. It changes, so all you have to specify is the methodology. Now, I would like to point out that on screen you do see remuneration does not necessarily include payments made by a principal to an agent as compensation. This means that you can't get away from enforcement under the anti-kickback statute by just not paying money. Enforcement actions have encompassed prime tickets to sporting events, vacation lodges, or personal or private flights to specific scenic destinations or galas. We've also seen a rapid and recent uptick in the use of liquor or alcoholic products and expensive cognacs or bourbons or whiskeys being cited as remuneration or additional compensation outside of the fair market value that will get you in hot water and take you out of the personal services and safe harbor. A number of other items on the checklist are on your screen for the purposes of everyone's time. I'm not going to go through every one individually, but a brief overview is that there must be an agreement in writing signed by all parties to that writing. The term of that agreement is not less than 1 calendar year from the date of its inception. As mentioned previously, the methodology for compensation is set in advance, and they do not involve counseling or promotion of a business arrangement or other activity that is otherwise in violation of state or federal law. These slides will be published to you directly later for you to review the checklist at your discretion. In the interest of everyone's time, we're going to move to the next slide. This is the second safe harbor that we pointed out, the employment safe harbor. The bona fide employee safe harbor to the anti-kickback statute states that there is no violation of the anti-kickback statute for a payment made by an employer to an employee who has a bona fide employment relationship with that employer for employment in the provision of covered items or services. The anti-kickback statute employment safe harbor exemption is an affirmative defense, which means the defendants have the burden of proof, which means if you attempt to use this safe harbor in response to allegations of the anti-kickback statute, you bear the responsibility, whether individually as the provider or as a whole as an organization, of proving compliance with each and every individual element of the employment safe harbor as you believe it applies to the actions at issue. The Fifth Circuit has previously found the safe harbor provision adopts the definition set forth in Chapter 26 of the United States Code, specifically found at 3121D2. The Fifth Circuit further noted that that where a federal statute adopts a common law definition of employee, the term incorporates the general common law of agency rather than the law of any particular state. This, translated from legalese, means the federal rules largely control rather than the individual law of any particular state. So the employee-employer relationship will be evaluated and scrutinized under the common law definition, as opposed to, for example, the state of Virginia versus the state of Georgia versus the state of California versus the state of Texas, whomever. There is one definition, and that is what will be used to evaluate compliance with the employment safe harbor. Once again, several other elements are on your screen, and in the interest of everyone's individual time, I'm not going to go through each one of them individually. You may feel free to reach out with questions or review them at your discretion and reach out at a later point in time. Next slide, please. So medical directorships are constantly in flux with the anti-kickback statute. The OIG in June of 2015 issued a fraud alert entitled "Physician Compensation Arrangements May Result in Significant Liability." This serves as a clear warning both to the physicians themselves and to the organizations who employ them. Specific language notes that OIG alleged compensation paid to 12 individual physicians under the medical directorship arrangements constituted improper remuneration under the anti-kickback statute for a number of reasons. This includes, but is not necessarily limited to, the fact that payments or remuneration took into account the physician's volume or value of referrals and did not reflect fair market value for the services to be performed. If you recall from previous slides, that is the number one first do not do when addressing compensation arrangements under the anti-kickback statute. Remuneration cannot take into account the referral rates, volume, or value of referrals that a medical director, physician, or any other party is bringing to the healthcare entity as a whole, or you risk running afoul of the anti-kickback statute. The OIG also alleged that some of the 12 physicians had entered into an arrangement under which an affiliated healthcare entity paid the salaries of the physician's front office staff. Once again, this is remuneration. It's an additional bump in compensation or items of value that is outside normal fair market value. In this case, the allegation is that the affiliated healthcare entity is paying front office staff in addition to medical director salaries, which is very clearly a violation of fair market value. Next slide, please. Some examples of problematic conduct that we've seen under the anti-kickback statute are business arrangements with individuals or entities that has the ability to refer business to your home health or hospice agency. While it's not inherently unallowed under the anti-kickback statute, because the taking into account the volume of referrals or net reimbursements that a business may provide to your healthcare entity is the first line of violating conduct under the anti-kickback statute, it is very prone to open up investigations under the anti-kickback statute. A continuing concern of the government also involves lease arrangements with actual or potential referral sources. Engaging or employing a medical director who makes referrals to your hospice or home health agency is a very common area of inquiry for law enforcement. Multiple medical directors doing the same thing further raises the level of risk and will increase government scrutiny. Old school dine and dash approaches may be gone, but bringing lunch and other goodies to a practice or office is still both commonplace and potentially problematic. I'll remind you, I mentioned earlier, the government is noting an uptick in increases for items like this. Very expensive lunches, very expensive bourbons, wines, liquors, alcohol of most kinds is really in the crosshairs and has been an uptick of AKS enforcement. Participating in any sham arrangements where a loan, research grant, or speaking fee is given to an entity from which your home health or hospice agency receives a referral. Giving cash, gifts, or other items of value, or really any remuneration identified as something of value, gift cards, sporting event tickets, or again, liquor to a referral source may violate the statute. Next slide, please. The anti-kickback statute also has False Claims Act liability. They were long viewed as separate and distinct enforcement tools where the False Claims Act approached the civil side and the anti-kickback statute applied in criminal kickback cases. Over the past 20 years, the enforcement landscape has slowly changed. Beginning in the early 90s, whistleblowers began asserting violations of the False Claims Act in cases that previously were simply criminal anti-kickback violations under the anti-kickback statute. These cases often involve fact patterns where a party was alleged to have violated the anti-kickback statute and, because of that predicate violation, in the process, billed for services that were allegedly worthless and made a false express or implied certification of the Medicare and Medicaid program. The 2010 passage of the Affordable Care Act, the ACA, obviated the need to bootstrap a violation of the anti-kickback statute into a violation of the False Claims Act, meaning you no longer had to get the predicate. You no longer had to put AKS first and then say, because we are alleging there is a violation of AKS, the False Claims Act comes into play. Specifically, a claim under the ACA, a claim submitted in violation of the federal anti-kickback statute automatically constitutes a false claim for purposes of the False Claims Act. It is a do not pass go, do not collect $200 automatic attachment of the False Claims Act and the civil liability associated with the FCA. Next slide, please. Medical revocation actions are also on the rise. This is often referred to in our field as the medical death penalty because it is the billing privilege revocation of an entity, whether it be a provider or an individual home health or hospice agency's ability to bill the federal or state Medicare and Medicaid programs. Prior to the 2019 expansion, revocation included one of the 22 reasons generally on screen. Once again, in the interest of everyone's time, I'm not going to go through each one individually, but the number one was obviously noncompliance. Prior predicate felonies also made this list, as well as improper prescribing practices, debt referred to the United States Department of Treasury, and billing from non-compliant locations or patient harm. Next slide, please. There are additional proposed revocation authorities. The following additional bases for revocation became effective January 1st on 2024. The first is the non-compliance revocation ground. CMS modified the existing regulation so several other enrollment requirements must be met. For example, the enrollment requirements pertaining to opioid treatment programs. CMS has expanded the language of revocation grounds to include all enrollment requirements regardless of their placement in Title 42, with which a provider or supplier must comply. Misdemeanor convictions have also been expanded. CMS has altered the language to say that CMS may revoke a provider or supplier's enrollment if they or any owner, managing employee, or organization has been convicted, as otherwise defined in the federal code, of a misdemeanor under federal or state law within the last 10 years that CMS determines to be detrimental to the best interest of the Medicare program and its beneficiaries. Misdemeanor convictions are a huge expansion because, as seen in the previous slide, it used to be just felony convictions. Increasing it to misdemeanors and those within the past 10 years is an expansion of Medicare revocation authority. False Claims Act civil judgments also allow for revocation. Specifically, CMS can revoke the enrollment of a provider or a supplier if they or any owner, managing employee, or organization officer or their directors had a civil judgment under the FCA imposed against them within the previous 10 years. For purposes of A15, however, civil judgments do not include FCA settlement agreements. It specifically says judgments against them. This is noteworthy for the legal side of the house. We, myself, Robert, and other healthcare attorneys can argue that in the event of an FCA settlement agreement, it does not run afoul of this revocation expansion. But as we mentioned earlier, each case is specific on each individual facts, and we cannot prescribe that as a general term of art. Each case is specific, and we urge you to consult counsel if you believe this may apply to you. Finally, violation of provider and supplier standards falls into number 1 on your screen. All enrollments requirements, regardless of their placement in Title 42, must be met. And finally, debt referred to the United States Treasury has been expanded to the provider or supplier's Medicare debt has been discharged by a bankruptcy court, or the administrative appeals process concerning the debt has not been exhausted prior to the appeal. Next slide, please. I'm going to turn it now back over to Salt for tips and tricks in responding to an investigation, specifically addressing half-truths and audio tapes. Salt?
All right, thanks, Matt. I know we just have a few more minutes, so I'll give you the brief overview of these slides. So, let's say your agency kind of run afoul of the law, and some FBI agents show up to, as part of the investigation. Well, normally, we've seen an uptick in law enforcement with these police body cams in order to record everything. Well, the FBI doesn't use that. Instead of those body cams or, recording the interviews, they'll normally come in pairs, and they'll document everything in these interviews on what's called an FBI Form 302. And, heaven forbid you come, through a subsequent trial, these Form 302s will be used as evidence as part of the investigatory process. So, one of the questions is, okay, while the FBI is investigating me, what can they say to me to try and elicit any facts or other information related to the case? Next slide. And one of these is, you can't lie to the government, but the question always arises, well, can government agencies or enforcement officials lie to you? And the general response is yes, under certain circumstances. So the Supreme Court has addressed this issue and said that generally law enforcement officials can lie to you during these interviews in order to elicit facts and information, provided that they don't use any trickery or deceit. And courts will also look at the totality of the circumstances, whether there is any undue pressure to you to provide a response, and otherwise that the interview doesn't, or the law enforcement officials' tactics don't shock the conscience of the court or the community. So, we provided, well, what are some examples of police conduct that could shock the conscience? Well, in one instance, an investigator was caught lying about his identity and introduced himself as the defendant's court-appointed attorney. Well, you can see how that could shock the conscience. Another instance in which an investigator posed as the defendant's clergyman in order to obtain a confession under the guise that the behavior, that sort of thing would shock the conscience. And then finally, courts over the years have upheld countless confessions, even though the investigator lied during the interview. And, these situations typically involve the investigator making false statements about certain evidence or eyewitness testimony that the government would depend on, or the presence of fingerprints, etc. So again, in sum, generally courts will allow, government investigators or officials to lie to you during these investigations, provided they don't use, really far from trickery or deceit that shocks the conscience. Next slide. And really lying to these government officials can get you into more trouble than the underlying conduct. So we have this case out in Washington where The provider lied about the number of times he checked vital signs, even though he knew that the statements were correct. So, when the case subsequently went to trial, the government didn't charge the provider with, billing violations. They didn't charge him with providing any controlled substances or opioid prescription violations. Instead, the government charged the defendant with making a materially false statement to the FBI. And that led to him facing nearly 5 years in prison, as well as a fine of $250,000. So again, as we even tell our kids, lying about something can be more problematic than the underlying issue. Next slide. Gio, next slide. I might be having some issues. Oh, there we go. Thank you. So kind of just to wrap everything up, as I mentioned at the very beginning, the government is really starting to focus more on individual culpability and going after everyone involved in any kind of criminal conduct related to healthcare fraud. So it's really important that you and your business are performing self-audits. That's just going to help you in your day-to-day conduct, but it's also going to help you identify any deficiencies and problematic conduct that could lead, to whether it's overpayments or, heaven forbid, any similar or criminal liability. You need to make sure that during those audits, you're identifying any potential overpayments and that you're returning them to the appropriate payor within the requisite time period. For those doing Medicare, we know about the 60-day rule. And hopefully you know about the recent changes that, you have 60 days to return an identified overpayment, but they changed when you identify an overpayment from reasonable diligence standard to, the FCA definition of knowing when that overpayment exists. And then again, as I noted, be mindful of the DOJ's renewed interest in individual accountability. I think it's still stand by to see whether the Trump administration renews what the Biden administration puts in place, or whether they kind of revert back to that standard of only those who were substantially involved in misconduct. And then finally, with everything, document. Document your efforts where you're fully complying with all the applicable statutory and regulatory requirements. And we really want to harp on that if you don't have one now, make sure you have a good compliance and ethics program in place. It's going to help you and your business stay within the four corners of the law and stay out of all the trouble that Matt and I have talked about today. Next slide. So that wraps up our presentation today. Gio, do we have any questions from the audience?
No, there are no questions. I think we're just gonna end it there.
Okay.
All right.
Well, thank you.
Yeah. So that concludes today's webinar. Thank you guys for joining us, and thank you to our speakers, Robert Saltaformaggio and Matt Catoe. Everyone from today's webinar will receive copies of the presentation tomorrow via email. If you have any further questions about today's discussion or another healthcare law issue, please feel free to reach out to the speakers or directly to Lowes Parker. Have a good Wednesday and have a good day.